Hi, everyone. Good afternoon. My name is Christina Berish. Thank you for attending today's 2002 Business Litigation webinar series. This topic here is on how to end a business relationship without litigating. Before we start, we want to cover a few housekeeping items, or we need to. If you have any questions during the webcast, you can submit them through the Q&A widget that's at the bottom of the screen. We'll try to answer as many of the questions during the webcast, but if a fuller answer is needed or we run out of time at the end, we may follow up and answer the question via email. Feel free to, again, we'd love to get some questions, so please feel free to submit questions throughout the presentation. A copy of today's slide deck is available in the resource widget, which is also at the bottom of the screen. We encourage you to download any of the resources or links that you may find useful. You can find answers to some common technical issues located in the help widget that's at the bottom of the screen. This webinar is CLE accredited in California, Illinois, and Texas for 1 hour of general credit. In Missouri, it's approved for 1.2 hours of general credit, and in New York, non-transitional and transitional for 1 hour of area professional credit. We award CLE based on attendance for the full 60 minutes. Due to some jurisdictional requirements, we won't have automated pop-up attendance checks, but we will be displaying secret words throughout the webinar. There's 2 instances where we're going to have secret words. At that time, we'll say the secret words, and you're required to select the word from a multiple choice list. Please respond to the 2 polls to demonstrate your continued engagement and to earn your full CLE credit. We value your opinions and appreciate your participation today in the course. We're here today. Again, our topic is ending business relationships without litigating. We're going to be presenting a lot of strategies to try to resolve differences, different kind of disputes before litigation arises. We're going to go over some different topics, and we have 4 speakers today. So first, Laura Jordan's going to talk about employee relationships and how to end those peacefully. I'll present next on ownership disputes, like business owner disputes. Katie Clark's going to talk about how to resolve, the contractual relationships and these business relationships.
Good afternoon, everyone. My name is Laura Jordan. It's very nice to have everybody here today. As Christina mentioned, my name is Laura Jordan. I am a partner in Thompson Coburn's Labor and Employment Practice Group. I'm thrilled to be talking with all of you today on what I think is a really important topic. Having been defending employers in employee disputes for a couple of decades now, we spend a lot of time talking with clients about employee terminations, and often that conversation starts after the employee has already been terminated or on the eve of the termination discussion, when really the facts are all laid out and the die is cast. That is often too late to mitigate your risk, and we are, as your outside attorneys, just left to work with the facts that we have, which can often be less than ideal. So I'm going to focus the next few minutes on talking about what I'll call the garden variety employee termination. While every employee termination has its own unique circumstances, the terminations I'm going to talk about are the ones that involve most of your employees. We're talking about at-will employees and not those typically within the executive suite. At the end of our presentation, Valerie will talk to you a little bit more about employees who have negotiated agreements and some other considerations. But before we talk about what we do to minimize your risk of litigation from terminated employees, I think it's important to start with answering the question of why do employees sue? Often in our kind of jaded worldview, we assume employees are just bringing a lawsuit to get money, thinking that if they threaten litigation, even if they think their claim has no merit, the employer will acquiesce and pay some money to just make the lawsuit go away. But Oftentimes when we spend time with employees in these disputes, we learn that there's a lot that goes into what leads an employee to call a lawyer in the first place. Filing a lawsuit against a former employer after you've been terminated is an emotionally burdensome process. Plaintiffs' attorneys will warn employees that when they sue their employer, they are likely to hear a lot of bad things about their performance. It can be an embarrassing process and often involve coworkers as witnesses who they thought were friends. And employment litigation can somewhat be similar to divorce litigation in that way. So why would someone go through that? Well, I would suggest you think about the first conversation a fired employee has when they come home from work after being terminated. Picture yourself coming home and facing your family or loved ones, telling them what happened. The level of surprise, outrage, or unexplainable events that lead to termination usually correlates to the likelihood that the employee is going to make a claim. In my experience, the top reasons the employees call a lawyer and consider filing a lawsuit is that they're surprised, confused, or embarrassed by the decision. If you've had a conversation about an event like that with your loved ones, you know what happens next. They tell you, that's outrageous. You shouldn't put up with that. You need to clear your name, take some action, stand up for yourself, and call a lawyer. When the employee calls the lawyer will inevitably ask them, what would your employer say is the reason you were terminated? And if the employee either can't answer the question or can clearly articulate why that explanation was bogus, that plaintiff's lawyer is more likely to take a case. From a lawyer's perspective, whether plaintiff side or defendant side, most lawyers will ask a few common questions to assess the risk of a discharge dispute or the viability of a lawsuit to bring against the employer. The first was the employee provided a fair chance to improve? In most involuntary terminations, we're dealing with a conduct or performance issue. So we look for things like, do we have a record of progressive discipline or coaching feedback? Is there balanced praise and criticism? We want to see whether the personnel documents make the decision maker look inconsistent or unlikable. How's the tone? Is it balanced amongst employees, or do we see something that looks like targeting or favoritism? Can the decision maker show backup for the reason for the decision? Do we have things like just-in-time documentation, or is the record something that was created after the fact, purely in anticipation of being sued? Is the employee sympathetic? The same factors that lead to the outrage at the kitchen table of surprise, confusion, embarrassment tend to make an employee who's been fired sympathetic. It could be something as simple as, could we have picked a better time? Did we fire somebody the day that she announced that she was pregnant? Did we terminate employees on the eve of a major holiday when they had to go home and face their family? Or could we have picked a better time? And then, of course, are the documents consistent? Does the message follow the records, or do they show disputed facts? Now, as lawyers, especially employment lawyers, we play Monday morning quarterback all the time, and oftentimes we are only looking at situations that don't end well. But in my Monday morning quarterbacking, I would say if you had one takeaway from me following today's conversation, it's this. The most effective way to reduce litigation from your employees today is to improve your performance feedback process. Many, and I would suggest even most of your supervisors and managers got promoted because they were good employees without consideration of whether they had the tools or the skill set to effectively lead and manage a team. Most supervisors and managers are conflict avoidant, and they often perpetuate bad behaviors of their predecessors. And nearly every company we see in litigation has a deficient performance process. And even though most employers have poor performance evaluation processes, we know that jurors still consider performance evaluations to be the best evidence of an employee's performance. And we know from case law that inflated performance evaluations create tangible risk for employers. We see cases like holdings that include a sudden change in a tenor performance evaluations can be deemed demonstration of an unlawful ulterior motive of discrimination or retaliation. Other cases have held that negative evaluations following years of raises and good reviews can constitute a cover-up to hire a less qualified employee. And another case held that an employer's claim of poor performance was not credible when based on an unsigned and undelivered performance review, and instead it would be appropriate to rely on the testimony of coworkers and friends. Because of this, I strongly recommend that you take a hard look at your performance feedback processes and see where you can make improvement. I can't stress enough how important it is to show that the employee knew what they needed to do to succeed, that they received balanced feedback, that they heard what they did well and not well, and finally, that the employer's money followed the message. If the employee is an average employee, they should receive an average increase. If they weren't performing well, perhaps they shouldn't receive any merit increase and nothing more than a market increase. Beyond the formal performance evaluations, the day-to-day personnel records and employee communications matter in litigation. Emails, instant messages, and text are all discoverable, and jurors consider these types of documents to be the best peek into the day-to-day experience of an employee. Strong, effective managers will communicate in a clear, direct, but respectful tone. So what are we looking for? We're looking for facts over opinions. We're looking for a degree of balance, some evidence that the employee's side was considered in a respectful manner. We're looking for fairness. Every single juror has had a boss, and bad bosses never win. The jurors are wise, and they can smell targeting and favoritism a mile away. They're looking at whether the supervisor communicates with the employee in a similar way to other coworkers. And we're looking for time. Has the employee given a fair chance to improve? Now, all good things can become bad things, and while documentation can be an incredibly useful tool in litigation and serve as an excellent memory aid, there is a point where you can over-document matters. Too much documentation focused on a single employee smells of targeting and unfairness, so be mindful of balance. And if you are participating in today's call in any risk management role, whether legal, HR, or otherwise, take a look and ask to review the records that are leading up to the termination decision, and ask yourself if it shows someone who's been treated with some degree of consistency among their peers. Now, briefly, I want to also touch on reductions in force. These are complicated processes, and we don't have enough time today to go through them in their entirety. But some food for thought, because good planning can go a long way in reducing your risk and litigation through workforce reductions. The process almost always occurs because a company is undergoing some sort of financial strain. And so the first thing I would say is that some transparency helps. Remember, surprised employees sue. So if employees understand market conditions, they're less surprised or embarrassed to learn that they're being affected by a layoff. And they will believe you when you tell them that you had to proceed with these because of the financial state of the company. Before you proceed with an involuntary termination, in some circumstances, a voluntary separation program in advance can be helpful. I would not say this is an all-the-time recommendation, but voluntary separation programs can be a useful tool to incentivize employees who really don't want to be there, or to incentivize employees who have fewer working years left because they're approaching their own anticipated retirement, to remove themselves from that involuntary pool of terminations to allow other employees to remain employed. These voluntary programs have a lot of legal traps, so you should be shepherded through this process with legal counsel before proceeding. But in the case of an involuntary separation program, it's very important that your selection criteria is clearly understood. Employees don't sue over a reduction in force, for example, where it's based exclusively on tenure. But in today's environment, we rarely see that that's the sole driver of a selection process. But if you're prioritizing something such as a certification or a specific skill set or a geographic location, make that known, because the employees who can't understand why they were selected and the person sitting next to them was not is the one most likely to seek the counsel of an attorney and consider bringing a claim against you. And finally, let's touch on the termination meetings. Again, the embarrassed, surprised, and confused employees are the ones who sue. And that the things that you do during the termination meeting matter. Number one, keep it short. Your goal at this meeting is not that everyone walks away feeling good or believes you with everything that you tell them about the termination decision. The goal is that the decision is respectfully and clearly communicated and understood. Generally, the best practice is to communicate the decision, let them know that it is definitive and final, and move forward on the next steps and forward thinking. So if you're offering severance or outplacement, make sure those opportunities are made known. If you're intending for a transition period, focus on how that process will work. But don't spend all your time talking about the reasons they were selected. It's really not the right time to do that. To have a smooth termination meeting, you also should be deliberate about who is present. If the direct supervisor and terminated employee don't get along, and that's known to you, think about whether you really need that supervisor to be present. Finally, avoid the parade. Allow the employees to pick up their items after hours or have them sent to them. Have the meeting in a discreet location where it's not visible to other employees, and consider whether, if the circumstances are appropriate, to coordinate with the employee how they message their departure. Remember, for many employees, this will be their worst day, so don't send them away with any more embarrassment or shame that may follow that. Christina?
Thank you, Laura. So my name again is Christina Berish. I'm a partner in our Chicago office. I'm also vice chair of our business litigation group. So I'm going to be talking today about ownership disputes. I've been a practicing lawyer for almost 20 years now. Most of my practice over those 20 years have been on contract claims, supply chain disputes, and all kinds of ownership disputes. And what I mean by ownership disputes or a business partnership, it can be any kind of business, whether it's a partnership, an LLC, or a closed corp. Usually it's, a non-public company with a dozen or less members. Sometimes for a lot of us on the call, if we're dealing with holding companies, they might have a number of subsidiaries. So those subsidiaries might have, a few members, and those are all kinds of business partnerships where disputes could arise. So that's what I'm going to be talking about today. Laura went back and talking about employees, talking about the reasons that employees might sue. I think it's equally good here to talk about why these business partnerships arise. In my years, there's two main reasons overwhelmingly why these business ownership disputes arise. The first one could be some sort of misconduct, whether it's one of the owners taking corporate opportunities, starting a side business, and not allowing the partnership to use that opportunity. So any kind of misconduct, using expenses improperly, things of that nature. And then the second one is one partner usually feeling like the other, or one of them is not pulling enough weight, and they're being compensated improperly because of that. So it's seen that over and over again. It also could be, with these corporate structures that the players change over time, and there's just personal disputes that arise between new players in the entities. So here are my 4 kind of tips to try to resolve these issues before you get to litigation. And I'll go through these 4 in more detail. The first being to prepare for dissolution in advance. When you're forming these contract documents, making sure that you're thinking about these issues, because it's really the best way to avoid any kind of dispute in litigation. Second, obviously to abide by the agreements, and I'll go into more detail about that. That if you come up with some sort of resolution, or through the course of time you come up with new agreements to kind of keep the business going, make sure that you document it and make it enforceable. And then, worst case scenario, finding ways to mediate or settle short of litigation. So before I go into each of these in a little bit more detail, we are now at our secret word. And today's first secret word is coffee. So please select the correct secret word, which is coffee, from the list below. Again, our first secret word is coffee. So if you have coffee, feel free to cheers us and drink our first secret word, which is coffee. We'll allow a couple seconds here for answers to go through. Again, our first secret word is coffee. One last time, our first secret word is coffee, and I'll move on to the next screen. So here for dissolving business partnerships. So again, the first tip I have is to prepare for disagreements in advance. So one of the first things to do is know who your partner is. Diligence your partner. Know how long they've been in business. If it's a corporate entity, know how long they've been in business. Know their background. Find out more about them. Usually when these business disputes get to litigation, I hear people say that, oh, well, I didn't realize that person didn't have as much experience as they told me, or something to that effect. Or their assets that they were bringing to the table weren't what they represented. So do some due diligence so you know who you're getting into business with. Being really clear about your roles and who's going to make the decisions. So again, one of the main reasons that there are such these ownership disputes is because people don't think that they're pulling enough weight, that the businesses aren't, if it's a joint venture, that one business isn't doing what it's supposed to be doing. So the sooner you can document and maybe put roles down and what each person or entity's responsibility is in the entity, the better and the more clear everyone is going forward. And then making sure you have an ownership document, whether it's, a partnership agreement or an operating agreement, having that and going through and documenting who makes the decisions. One of our partners, Rob Lang, he wrote an article that's on our website, thompsoncoburn.com, and the article kind of goes through the specific things to look for in an agreement when you're documenting them, the main parts of the agreement that cause a lot of trouble, down the road. Some of those are about distributions, making sure everyone is clear about when distributions will occur. On expenditures, same thing, making sure people know when expenditures will happen, and then buyout issues as well. When can one partner buy the other out? If you have a corporate entity where an employee is also an owner, what happens if that employee is fired? What if the employee is fired for cause? Will that automatically trigger a buyout? So thinking through those issues in advance when you're documenting the entity. You know, corporate entities, like these business partnerships, are unique because there likely will be an end. There will be an end at some point. So the operating agreement, the partnership agreement should document how it will end very thoroughly and thinking through the steps of it. One thing I noticed that situations work out better and resolutions work out better when the buy-sell provisions have timelines for when certain things will occur. So the more clear you are, even in terms of timing, the better results will happen later when there's a partnership dispute or a dissolution. The second tip I have is to abide by the contract documents. So you have a partnership agreement, you have an employee agreement, if there's an employee owner, making sure that you're abiding by the contract, the employment agreement, so that once the dispute arises, you're not the one that's in breach of the contract. So it can be enforced. If litigation arises, it can be enforced. So there's not allegations that you or your client are the ones that are actually in breach. I also see where step one, an entity documented a buy-sell or a dissolution provision and had a valuation, and they did it well, and it was based on a certain metric in their financial statements, but then you don't prepare your financial statements. So again, making sure you're abiding by the documents and that you have what you need in place to get the result that you want. A third tip would be, sometimes when these disputes arise, the owners will come to some sort of kind of interim agreement. But an interim agreement can really be an amendment to a partnership or an operating agreement. So when you have any sort of interim agreement, using that as a time to making it formal and making it a formal signed amendment. Another thing I see happen sometimes is that these interim agreements are not. Someone might think it's an interim agreement. One person might think it's just a guideline rather than an actual agreement, or they don't know what the terms of the agreement are. So by documenting it and actually signing it to make sure that everyone's in agreement with that amendment. And also thinking through when you have an amendment to a partnership agreement, what the consideration might be for that. So if you have a situation where you have like an employee owner, thinking through the consideration, making sure that the amendment's a valid one. So fourth, here, finding ways to mediate or resolve the dispute, again, short of litigation. So first, depending on the reasons for the partnership dispute or the ownership dispute, whether revisions to the partnership agreement would resolve some of these issues. So, in instances of employee misconduct, that likely wouldn't be something you could then just, revise the partnership agreement. But where you have a situation where one of the members thinks that the compensation is inappropriate going forward, or one isn't fulfilling the roles, or that they should alter their roles, really thinking through whether the dispute could be resolved through an amendment. Also then, before you litigate or come to some sort of agreement, know what you're fighting about. So usually valuation is a disputed issue, but at least on your end, getting a valuation so that you know whether to fight, how much to fight, and how to resolve the matter. So again, here there's buyout, putting the buyout, in the beginning when you're drafting the documents is best, but a buyout is a typical way to resolve the dispute. One thing I like to see, so buyouts, it's difficult sometimes for one of the owners to buy out the other automatically and to come up with the cash or whatever the consideration is for the buyout. So it's good if you can to try to, when you are drafting the buyout provision, have a term, whether it be, a payments over 5 years or some sort of term for the buyout to occur. Selling to new owners is an option. And then, worst case scenario, if the owners can't continue running the business together, considering selling assets. Sometimes these disputes are arising because of financial issues occurring, so consideration of bankruptcy or liquidation. And with that, that kind of brings us to our next topic, which my partner Katie will talk about, which is how to resolve these disputes when you have some sort of financial difficulties.
Thank you, Christina. My name is Katie Clark. I am in Thompson Coburn's Dallas office, and I do both commercial litigation and I am a bankruptcy practitioner. So my comments today are informed by both of those roles. And so, and kind of obvious from the title of my portion, which is Tips for Concluding Contractual Relationships in Times of Financial Instability. So first things first, even though in times of financial instability, it can feel like there is a fire going and so you have to move lightning speed, take the time to gather information, mainly to review this governing document or documents that form the contract or the writing that govern the parties' relationship. You want to be sure in that review to note provisions that are in favor to where things stand as to your position and any challenges that there might be. And that's kind of generic, but each contract, depending on the focus, those things that are in favor or challenges are going to, they're going to change. However, something that you want to pay particular attention to, no matter the type of agreement, are whether and to what extent there are termination or breach guidelines. That is, if you're wanting to terminate the contract, financial instability notwithstanding, what does the contract say, if anything, should happen if one party would like to terminate the contract or if there's been a breach, and how are the parties to the contract to address those? What notices are to be given? How are the notices to be given? A lot of times in this day and age, we are so reliant on email that we send emails to one another, and yet our contracts don't typically touch up with that. And so you might have to send a good old-fashioned letter by certified mail, and that may be out of the norm for you. And so just be careful to look at those notices in terms of notice provisions, in terms of the method, and what timeline is out there. And in this context, for when there is financial instability, those timelines could present a challenge, but you need to know them and determine if it's something you can or should try to work within. And finally, is there anything in the contract that talks about monetary consequences for terminating the contract itself? And most frequently, this might be something like a liquidated damages clause. In addition, as you're reviewing the governing documents, the contract, look to see if there's anything that you need to do for your own part to ensure that you are in compliance with the contract itself. So are there any outstanding performance issues? Are there covenants that may be technically in breach that you can cure even without the other side asking you to do so? Do you need to, does the contract give rise to a security for you, and do you need to perfect that security interest by filing a UCC1, for example, or any other similar cleanup that would help secure your position? And I think that's a particularly important point when there is financial distress on the horizon. With one caveat, we'll talk about this toward the end. If there's bankruptcy on the horizon, that you might, you'll need to proceed with caution in taking those perfection type actions. And you'll also want to assess the overall monetary risks. And this is different from a liquidated damages clause in the contract. What I'm talking about here is, does the contract counterparty owe you money? And how much? Or have you invested in some sort of a product that you were counting on your counterparty buying? And even though the relationship needs to conclude, what will you do with these outstanding monetary issues? And it doesn't have to be precise, but you want to get a sense of where things stand. You'll also want to consider, as a general matter, what are some possibilities after the termination? And some of this is along the lines of what are you trying to accomplish? It may or may not be informed by the contract, and most likely it's going to be informed by the facts that are particular to your contractual relationship, any dispute that might be out there, and what's the nature of the financial distress that is being faced. But is concluding the relationship so that your company or you can take over your contract counterparty something you want to consider? Is replacing management really what needs to happen, or that's your ask and you're hoping that you can get that done because the contractual relationship will otherwise be untenable, notwithstanding the financial difficulty? Is your company someone who can provide a partnership or help alleviate whatever this financial distress may be, and are you interested in exploring that particular option? Or do you just need to think about renegotiating a contract? For example, should you reduce the duties that your client has or that you're asking of the contract counterparty in order to retain some sort of contractual relationship, albeit in a reduced capacity? Okay, now we are to our second secret word, which is Apple. So please select the correct secret word on the screen below, which is Apple. If you're into pop culture, you might be wondering which celebrity actually named their child Apple, and that is Gwyneth Paltrow. So I'm going to just give a few more seconds for parties to select the secret word. Secret word is Apple. Okay, I'm going to move on. So if you need to do so, please select the secret word, and that is Apple. One thing that factors in my experience, to these contract termination discussions when financial distress is very present or very much on the horizon, is that there is a human side. And that often, in addition to feeling like things are on fire just due to the financial nature of the situation, it can feel that way in terms of the way that each individual is processing what's going on. So there might be increased tension. You might feel very pressured to make a quick decision. And on top of all of that, there may be a lot of emotion wrapped up because this financial distress was not part of what that either party expected going into the relationship. And some things that I hear that let me know that that emotional decision making may be part of the risks that we need to mitigate. I hear things like, a deal is a deal. Oh, they would never not perform or pay us eventually or exercise this potential provision in the contract that hurts us, or yeah, we can terminate, but and for now we won't get paid, but they're good for it, or their principal's good for it, don't worry. Or, you know, the old, let's just do what's right. They need to do what's right. This is unfair where we are, and they need to make it right. Any iteration of those sorts of things tell me that the parties are emotionally invested, and that is something that everybody needs to keep a watch on. Because on the whole, you just got to be able to accept and consider the economic realities and also the potential for litigation and move through those with that emotion as best you can, but try not to speed things up unnecessarily, whether that's because of the financial distress or sort of just how you're feeling in general. And so in ways to do that, ways to work through this emotional decision-making is to really focus on, you know, what's your desired outcome or top priority or priorities. And so you might desire a complete walk away. You never want to do business with this party again. You might just be focused on minimizing losses and expense overall, which will, you know, there's a lot that would need to go into that thinking in terms of if we had to litigate, what would that look like, and various similar types of logic exercises. Is this really a big issue? Do you need to draw a line in the sand and go from there? Is that what's going to inform your next steps and your decision making? Or are you really trying to get the highest monetary return? Do you need to do some back of the envelope calculations, or maybe bring in a party that can really, you know, put things through their supercomputer massive spreadsheets and give you thoughts on the best strategy as a way forward? The other thing to consider, even though today's talk is about avoiding litigation, is that if unfortunately litigation comes, and in my world with financial distress, it often does, no matter what you're trying to do on your side of the fence. You just have to remember, as in any litigation scenario, that what you write down, be that in an email, a text message, a WhatsApp, or whatever a new platform might be out there, that can show up as evidence later on down the road. So if you've also got this emotional decision-making, or there's high emotion that's percolating, I think that's an important point to just keep in mind. And so when it comes to writing, less is always more, even though, you know, there's going to be some, in theory, there will be some sort of writing. You want to just focus on the necessary as much as possible. And the other thing, as you're going through your decision-making process, as you think about how to best terminate the relationship, is, and this is very important when you've got financial distress, is you've got to balance the reserving your rights in case litigation is the next step, and then are there any pragmatic resolutions short of litigation that you can live with? And then this echoes Christina's advice in her discussion. If you reach a resolution, you need to document that, and you need to be careful in how you do so to ensure that the parties truly have a meeting of the minds and everyone understands what the next steps are. And so my last slide, and last but not least, is the B word, which is bankruptcy. I know no one ever likes to have to call me if they are a creditor in a bankruptcy case, but it is important to have and know a bankruptcy lawyer that you can call if this circumstance befalls your client or your particular company. And so in the context of thinking about the end of a contractual relationship in times of financial distress, one thing is, are we talking about actual bankruptcy filing? Your contract counterparty has actually filed a bankruptcy, or are they threatening the bankruptcy? And so those two things are obviously very important, because a threat, you still have some time to work through and be very intentional and careful about how you want to resolve things, and you have a lot more flexibility in resolving a situation before a bankruptcy is filed. And then once the bankruptcy is actually filed, I wouldn't necessarily automatically say that means that now the matter has moved to, quote, litigation, but you are in a court at that point. You have no choice but to deal with the contract counterparty through the bankruptcy court And so things have changed in terms of what you're going to be able to do and your risk analysis, how much money you want to spend, et cetera. And so one of the first things and simplest things is just what's the status of the relationship if a bankruptcy is filed at the time of the bankruptcy filing. Are you owed money? Is the contract set to end at a certain time? Very importantly, once a bankruptcy is filed, there is an automatic stay that goes into place. That's from the bankruptcy code. Congress has basically said if a party files for bankruptcy, they get to have a breathing spell and consider their next steps of what they're going to do with their company. And so you need to be careful that you're not sending demand letters, you're not filing your UCC-1. If a bankruptcy has been filed, you're going to need to proceed with caution at the very least. What type of bankruptcy has been filed is very important. And if that statement sounds like a foreign language to you, I highly recommend that you dial up a bankruptcy expert so that they can help you at least make some initial decisions, get you oriented to what's going on, especially if you've never been involved in a bankruptcy. They're not intuitive, and there can be some simple things to do at the front end of a case or during a case. And if you don't know what you're to expect or how to navigate, you might miss those things, and that could take away some options that you might otherwise have available, and they may and those options within the bankruptcy may not cost that much, but you could lose them depending on the timeline. And then the last point is just to consider, even after your contract counterparty that you're trying to conclude your relationship with has filed for bankruptcy, do you now have to perform, or does your client now have to continue to perform under the contract, even though the contract counterparty has filed for bankruptcy? And again, you would want to talk to bankruptcy counsel about that, but that is something that comes up very frequently. So that leads us to Valerie.
Thank you. This is Valarie Bomar. Hello, everyone. Can everyone hear me? I joined Thompson Coburn about a month ago in their business lit group. Prior to that, I spent about 15 years in-house for 3 publicly traded companies. And prior to that, I was at private practice and law firms. I've been practicing for about 25 years. So I'm approaching this presentation from the perspective of in-house counsel. I dealt with both employee and business partner disputes when I was in-house. So let's just jump on the employment side. I will probably touch upon some of the topics and tips that Laura talked about earlier, but I would say the lion's share of the employee disputes I had to defend in-house was typically because the former employee felt mistreated or didn't feel their situation was properly handled. I would argue that in most of those cases, had the matter been handled differently from the onset, we would have likely avoided litigation. Of course, that's pure speculation. Some people just like to sue for the sake of suing. But I found that when departures were handled with empathy and where the employees felt a sense of dignity, there was no litigation. I chose this picture on this slide because her expression is saying a lot. And some real examples from my in-house experience. She's upset because she just received an email from her manager attaching her performance review, which was the lowest ranking she had ever received at her tenure at the job. And by the way, her male manager had only been hired 2 weeks prior, but evaluated her performance for the entire year. And her previous manager gave her outstanding reviews, including an outstanding mid-year review. So she's not understanding what's happening here. She's upset because she was told that because she exceeded her allotted vacation sick time by 1 day, she would be terminated. And by the way, she exhausted her time off because she had a severe illness and needed the day as a single mom to stay home with a sick child from school. No one disputed her reason for needing the day. Everyone believed she was at home caring for her child, but that 1 day over was 1 day too much. And oh yeah, she just requested FMLA leave before she was terminated. And just one final example, she's upset because there was a rift and her peers were able to obtain other comparable jobs and stay employed, but she didn't get placed, and she lost her employment. And by the way, she was the oldest, one rift, and by the way, she had just returned from medical leave and was receiving accommodations. So again, these are just a few examples, but most of the cases I had to go to litigation had similar fact patterns. I mean, fact patterns where you said to yourself, now what happened here? And then most of these could probably be explained eternally. There was always a reason behind the actions, but could they really be explained in front of a jury? And that's the question we have to ask ourselves. So here are some of my suggestions that I found to be helpful when I advise my internal clients on how to avoid litigation. In the first instance, on the employment side, first, just listen. You know, I found that most employees really just want to be heard. They want you to listen to their complaint about their manager and how unfair they believe they've been treated, or whatever the case may be. Hear these employees out. I find that when employees believe that they are being heard, that they're more agreeable to the departure terms. Second, be responsive and show the money. I mean, once it's determined after listening that this is really an unfixable situation and it's best for everyone just to really leave, for this employee to leave the organization, get back to that employee as soon as possible for with your departure terms. Circle the wagons and determine how much authority you will have to resolve, either because this employee has threatened litigation or you know the fact pattern that you're dealing with is something you want to bury as soon as possible, even if the employee didn't threaten litigation, or you believe this employee is probably likely going to sue and it would be cheaper to kind of throw money at it, get a release, than to litigate. I would say always loop in legal, especially when there's a rift and reassignment has been made, are being made. You want to make sure, and I think Laura touched upon that earlier too, you want to make sure that reassignments are done with fairness, transparency. Was the job posted? Did everyone get a chance to apply? Was there an objective criteria for the reassignment? So my advice would be to always loop in legal when necessary, but especially if there's going to be some reassignments during a rift. Before termination, you use common sense. Show some compassion. So when advising a client, ask yourself, how would this play in front of a jury? So the woman that I referred to earlier that had the severe illness and took one additional day to care for her sick child, should she have really been terminated? It wasn't like she was a no-call, no-show. She called. No one disputed that she was at home taking care of her child. But the company was technically in the right. They technically were in the right to terminate her because she exhausted her days. But should they have? So I would argue probably not. To say the least, the EEOC agreed with her, and we settled this case pretty quickly. But I would say, and I think Laura mentioned it before, just put yourself in the employee's shoes. How would you feel if this was you? How would you feel if this was your sister? How would you feel if this was your mother after receiving this type of news? A couple of more things I want to point out. If there's an employment agreement, read and comply with the agreement. You don't want litigation on the back end. So if there's an accelerated vesting clause or things of that nature, make sure your HR and your payroll knows of any special arrangements and that the employee gets his or her money. And don't assume that provisions that are in the employment agreement are still enforceable today, especially when you're dealing with an older agreement or a long-term employee. For example, you might have restrictive covenants or non-compete clauses in an employment agreement that are non-enforceable today under different state laws. So just make sure that whatever you're trying to enforce is actually enforceable. And avoid future litigation by complying with the laws and regulations. Follow the local rules regarding proper notice of termination. Some jurisdictions, especially outside the U.S., they require a lot more hoops to jump through, both before and after termination. In some jurisdictions, if you're terminating outside the United States, terminating an employee for cause, you have to do an immediate investigation, and the investigation has to be completed in X amount of days. But there's a lot of hoops sometimes outside the United States when it comes to terminating employees. So if you terminate without meeting local jurisdiction requirements, you will undoubtedly get sued. Okay. So as to business relationships, whenever there is talk about terminating a business relationship, whether it's because of poor service or you simply no longer just need or want the service, the one case that always comes to my mind, it was a case I handled at Kraft. It's a public filing, so I'm not disclosing anything confidential. At Kraft, we had a requirements contract that required us to sell to our customer at least 4 million pounds of turkey a year. It's a turkey case. Well, that same year was a bird flu outbreak, which led to severe shortages of turkeys. And Kraft wanted to substantially reduce the amount of turkeys that they sold to this one customer given the outbreak. So initially, the business did what they should have done. They picked up the phone, called the other side, and said, hey, can we reduce the amount of turkeys we're selling to you? And the other side said, sure, as long as you sell it later and make up the difference. We agreed, and we made up the difference for some period of time. And then we decided to just stop making up the difference and not selling them at all. And we probably should not have done that because we got sued, and the court was not happy with our refusal to sell turkeys to this one customer and ordered us to supply the turkey under the contract as we contracted. But now, because of our delay, it was on a very, very, very accelerated basis. It was not a good outcome, especially during this time. To source turkeys was virtually impossible. But that was what the court decided, and that's how that case went. And so what could Kraft have done or differently or in any situation where you want to terminate a business relationship and not litigate? When I advised my clients, the first thing we did was we just read the contract. Know what you can and cannot do. It's advisable to probably loop in legal with this evaluation. I would argue if legal had been looped in at the beginning of that turkey case, we would have advised the business that the contract was a requirements contract and not aspirational. So loop in legal when necessary, especially when there's doubts on what you can and cannot do under the contract. But after you read the contract, if there's really no out under the contract, oftentimes there is not an out. Oftentimes there's no real reason that you can terminate. That doesn't mean that you can't breach or terminate the contract. You can. And the best approach is to communicate. Have a conversation with the business partner. In a turkey case, the customer agreed to a workaround. And they may have agreed to a complete termination for the right price. So you have to be prepared to show the money. Know how much you're willing to pay to terminate the contract where both parties agree just to walk away. The only other thing I would add is, similar to employment cases, I often advise my clients to treat their business partner with respect and dignity. Don't have the attitude of, I'm just going to do it because I can, especially when it's a big company against a small business owner, which was the perceived dynamic in the turkey case I talked about earlier. So always consider how your actions will play in front of a judge or jury. And that's all I have. Christina, do you want to turn it over to questions?
Thank you, Val. So for questions, one, we got a question about who is Gwyneth Paltrow, which relates to our second secret word. We also received a question about there's a lot of uncertainties at the beginning of a business. When there are, can you advise parties to set a timeline and revise documents at a later time? What I would say is one of the things that I think leads to litigation the most are when parties agree to punt a decision and agree at a later point in time. So to the extent any decisions can be made now, or parameters, or kind of contingencies that if these metrics are met, this will happen. If this happens, is better than we'll agree to talk about it at a later time. Because at that point you might just be inviting a dispute. I don't know if any of the panelists have other thoughts on that. We appreciate your time today. We have 2 upcoming webinars on June 1st on class actions and an ethics CLE on corporate client privilege. And if you can please fill out your evaluations. They are located, I believe, on one of the widgets. And thank you for joining us today. Bye-bye.